Okay, folks, we're going to be talking about states' rights today. And the reason that I want to talk about that is that states' rights has come back into the news somewhat on account of the Roe v. Wade overturning. When Roe v. Wade was overturned, abortion was no longer a federal issue and it became a states' rights issue again. Now a state is free to ban it entirely or it's free to legalize it entirely. It's all up to the states now, and that makes it a states' rights issue. Now, there are people who want to slyly make the association that the Supreme Court has turned abortion law into a slavery issue, saying, now women are being enslaved, and you can tell on account of the use of the term states' rights, as if states' rights and slavery were somehow synonymous. Now, granted, in the Civil War times, it largely was synonymous. Slavery was a state by state issue. You had free states and you had slave states, and the free states and the slave states didn't like each other very much. And, and it was for that reason we later had a very, very bloody Civil War. Now, the problem is that states' rights on that account have generally been universally associated with slavery, with a pro-slavery cause, but that's not always been the case. And I wanted to bring forth a very important example of when states' rights was actually used to make an anti-slavery case. And so this is the tale of how states' rights nearly saved Dred Scott. Dred Scott, if you recognize the name, is the plaintiff in the case Dred Scott v. Sanford. John Sanford being the defendant in this case. Oh, and by the way, you might know this title as Dred Scott v. Sandford, Sandford, and it is actually still recorded as that in the annals of the Supreme Court. So if you ever try to look it up in the official court register, you're going to have to add the D. But in fact, his name was Sanford. So I'm just writing it there here. Now, what is the background of the case? Well, Dred Scott was a slave born in the U.S., and he sued his former master, John Sanford, in federal court, claiming that he was freed after having been brought into a free territory voluntarily by his master. Now, what this kind of triggered in the legal process is that if a slave escaped into a free state, then by Article 4 of the Constitution, that state, the free state, was obligated to return the slave to his master. So that was a case of escaping the master's clutches, fleeing to a free state, and trying to gain freedom that way. The Article 4 of the Constitution did not permit that. However, if a master were to take his slave voluntarily into a territory in which the condition of slavery did not exist, that was tantamount to freeing your slave. You could not keep that person in a state of slavery in a free state where slavery was not recognized. So if you voluntarily took your slave into one of these areas where slavery was not allowed, then that slave would be freed. Now, the question, however, was raised on account of the fact that Dred Scott was suing to try and prove this. The problem is that in order to sue in federal court, you have to be a U.S. citizen. Was Dred Scott a U.S. citizen? Well, that was a big question. And it was a question nobody had answered yet, although it had been bounced around in the courts leading up to the Supreme Court. The big question on the table was, does a black man born a slave in the United States after being released from slavery become a citizen of the United States? It wasn't necessarily clear that that was the case. Now, the majority opinion in Dred Scott v. Sanford was no. He does not become a citizen. The reason being, this is kind of a general simplified overview of the logic, is that the Constitution grants Congress, not any state, the power to naturalize aliens. This is basically foreigners, anybody who's coming into the country from some other country, having previously had allegiance to some other country. Slaves, being the children of people originally brought over from Africa, are essentially aliens. That was what the majority was saying. And Congress had passed no law naturalizing freed slaves. They had passed laws naturalizing people of other countries, Generally, it was also restricted to white people of other countries, but at least they had naturalization laws on the books, and I believe they had some naturalization laws concerning the Native Americans as well. So, in those cases, you could have people become citizens, but in terms of the slaves born of those original Africans brought over from Africa, there were no naturalization laws as yet. And therefore, a slave, if freed, does not become a U.S. citizen. So that was the basic reasoning of the majority opinion. Now, the dissenting opinion, of course, said that yes, a slave does become a citizen. Why? Because the Constitution says it's possible to be a natural born citizen, but it doesn't say exactly how. It doesn't say whether just being born on U.S. soil is enough to make a person a citizen. It doesn't say that you have to be of this particular parentage or whatnot. And because the Constitution doesn't actually give a definition of who is a natural born citizen or not, it is assumed, on account of the 10th Amendment, that the power to define a natural born citizen is left to the states. Well, it just so happened that in the States, anybody born on, say, Texas soil or Maryland soil or whatever state soil is a citizen of that state. That person is a natural born citizen of that state and therefore a citizen of the United States. So the states have it in their power to say, hey, look, if somebody's born on our soil, whether that person be free or slave, yes, that person is a natural born citizen. Now, understanding that the condition of slavery is something that is imposed by law, it's not something that is a natural trait of human beings. Slavery cancels out a person's natural born citizenship until such time as that slavery is removed. Therefore, a slave who is born on U.S. soil reverts to natural born citizenship status upon being freed. So, under this logic of the dissent, Dred Scott should have been recognized by a citizen. Now, as it was under the majority opinion, he was not. Now, which of these two opinions, though, is the states' rights opinion? If states' rights is always pro slavery and always favoring the institution of slavery, you would expect that to be the majority opinion. However, the majority opinion is giving all the power in this case to Congress. It's interpreting the case strictly through the lens of Congress's naturalization power, and therefore it makes this case a federal case. However, the dissenting opinion deals with the question of who is or is not a natural born citizen and says this definition is under the power of the states, so that it's the states who have power to define who is a citizen or not. That makes the dissenting opinion in the Dred Scott case the states' rights opinion. So I just want to show you here that states' rights and slavery, these are not synonymous terms. In the case of Dred Scott v. Sanford, you actually had a case in which the anti-slavery position, the position that Dred Scott would have liked to have seen go through, was actually a states' rights case. So it's time to stop slandering the term states' rights as if it's a universally evil term. That's just not the case. I'm Mike Partika. Thank you for watching, and please do subscribe if you haven't already so you can get more lessons like this, and I will talk to you later.